Hi Constitutional Law class, as discussed, this video is going to give a preview of the First Amendment. As I mentioned in class, I am not going to put this material on the final exam, although this material can and will be part of the final quiz. So let's look at the First Amendment itself to begin with. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. What we really want to talk about here are just some general principles. If you take a First Amendment class, obviously you're going to dive in depth into many of these principles. First general principle is this, and this is all based on many years of Supreme Court case law developing that language that we looked at in the First Amendment. Content-based restrictions, that is a restriction that concerns the actual content of speech, in general are going to be subject to strict scrutiny. Now notice, this doesn't mean there can't possibly be a content-based restriction, but we are going to look for a compelling state interest and a close fit between that compelling state interest and the restriction under consideration. Time, place, and manner restrictions are going to be looked at in a different way. So time, place, and manner restrictions are those that are not necessarily geared at the content itself, but are geared at the time in which the speech is given, the place in which the speech is given, the manner in which the speech is given. So what we're going to look at is whether, in fact, the restriction is content neutral. We're going to look for significant governmental interest, not a compelling interest. We're going to look for whether the regulation is narrowly tailored to that significant interest, and whether the regulation leaves open ample alternative channels for communication. In general, not protected under the First Amendment, so there are speech is generally protected under the First Amendment, but there are categories of speech that we're going to say that the government usually can regulate, and we're usually not going to have a problem with that regulation. And that includes a category called fighting words and another category called true threats. So fighting words, if you were convening an assembly in a public park for the purpose of staging a riot, that speech and assembly would probably be fighting words. True threats, you are communicating an actual threat to someone. Maybe it's in the context of extortion or something like that. The law can prohibit that kind of communication. Obviously, as you can see, if you get into the cases, what exactly is fighting words versus just something provocative, what in fact is a true threat versus some other kind of perhaps just unpleasant speech. There's lots of case law on that. Another interesting category that the court has wrestled with over the years is obscenity and pornography. So over the years, the court has developed a test called the Miller test, which is up here on the screen. So whether an average person using contemporary community standards would find the work as a whole appears to the prurient interest, whether it describes in a patently offensive way sexual conduct specifically defined by state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. If what the state regulation is geared at satisfies this test, then the state or the federal government, the law could regulate that kind of speech. Good example here, child pornography, and there are other cases that follow up. A case called Ferber that follows up and says that child pornography, if there are actual children involved, is always going to satisfy this test. As you can imagine, then there are lots of other categories of speech where you're going to apply these standards, and it's going to be very difficult to apply them. Let's take a look now at the religion clauses. So in the religion clauses, you'll notice there is an establishment clause and there is a free exercise clause. So the test that is commonly applied in establishment clause cases is from Lemon v. Kurtzman in 1971. That test is going to require that the state action has a secular legislative purpose, that its principal or primary effect is one that neither advances nor inhibits religion, and that it does not foster an excessive government entanglement with religion. So as you're probably aware of just kind of from popular media, there's lots of cases at the margin, like, for example, religious symbols on public property, at a holiday time. What kinds of things can be taught in public schools regarding religious theories about creation versus evolution or things like that. All those sorts of things raise difficult questions under this test. Under the free exercise clause, and we noted this in looking at Bourne v. Flores in this unit in Congress's enforcement powers under the 14th Amendment. So previously, the court applied a strict scrutiny test to state actions that unduly burden religion or religion's observance, and that was Sherbert v. Werner. In 1990, in the Smith case, the court said that a neutral law of general applicability that incidentally burdens religion is not subject to strict scrutiny. Now, just as I mentioned, even after Smith, a facially neutral law that targets a specific religion, and there's cases involving, kind of out of the mainstream religious observance like Santeria practices and so on. But if the law targets a specific religion, it's still going to be held unconstitutional. Now, in 1993, Congress passed a statute called the Religious Freedom Restoration Act, which restored the Sherbert strict scrutiny test. As we have seen, that statute was declared unconstitutional as applied to the states in City of Bourne v. Flores, but the statute still does apply to the federal government. If you take a law and religion class and you will study the Burwell versus Hobby Lobby case, which you might recall was one of the cases kind of spinning out of Obamacare. Just also note a recent development, which is Hosanna Tabor Evangelical Lutheran Church and School versus EEOC, which establishes that there's a ministerial exception to employment discrimination claims, so that if an employee is in this category of ministerial, then the organization can have specific requirements relating to religious beliefs or religious lifestyle practices that might otherwise violate employment discrimination laws, for example, state employment discrimination laws that protect LGBTQ people. But if the employee is not a ministerial employee, then the state laws of general application would apply. And obviously the question then is going to be, what is a ministerial employee? I didn't put the Masterpiece Cake Shop case on the slide, but that's worth mentioning. So if you recall, that's a case in which a owner of a local bakery in Colorado didn't want to make a wedding cake for a same-sex couple, and the state civil rights authority under state law sanctioned the bakery owner, and he claimed that he had both a free exercise and a free speech right because he claimed that his cakes were artistic creations. And that case did get before the Supreme Court, but ultimately the Supreme Court really punted and said that the state authority had displayed specific animus against the baker. So the general question, which is still one that is being litigated in various places, about whether a business owner claiming some kind of religious connection to their otherwise secular business can have exemptions for these kinds of employment laws is really undecided. So that is your First Amendment teaser, really just designed to give you a taste for what you will encounter if and when you dive into a deeper, more specific study of the First Amendment.